Hey everyone, Attorney Shay here. Today we have some groundbreaking news that's shaking up the world of comic books and intellectual property. The U.S. Patent and Trademark Office has recently canceled some of the longest standing trademarks jointly owned by Marvel and DC Comics. You'd be surprised to learn that trademark registrations for superhero and superheroes has been canceled. This decision could have major implications for comic fans, creators, and the industry as a whole. So let's break down what happened, why it happened, and what it means for the industry. For decades, Marvel and DC Comics held joint trademarks on the word marks superhero and superheroes. Despite being fierce rivals, they joined forces to secure exclusive rights over these terms, creating what some saw as a duopoly over the superhero genre. But recently, all of that changed when a company called Super Babies Limited, owned by comic creator from London, S.J. Richard, took on the comic book giants in a trademark dispute. Super Babies produces comic books about superhero babies, and they were put in the spotlight when Richard applied for a U.S. trademark for Super Babies, the name. Apparently, DC Comics accused Richard's company, Super Babies Limited, of infringing upon the superhero marks and threatened legal action. In response, Super Babies boldly fired back by filing a petition with the Trademark Trial and Appeal Board to cancel Marvel and DC's long-standing registrations for superhero and superheroes. The core of their argument, the terms superhero and superheroes had become generic. Let's break down what that means. A term is considered generic if it describes a good or service by its everyday name. Think Apple being used as a trademark for apples or candy shop for candy shop. Under U.S. trademark law, a generic term is not a trademark at all. Super Babies argued that the words superhero and superheroes are widely used to refer to a genre, not just to Marvel and DC characters. They presented historical evidence showing that the use of the term in media, toys, and other third-party products did not tie directly to one of the two companies. DC didn't respond. They didn't respond to Super Baby's petition at all. They didn't challenge it. They didn't provide any evidence. They didn't defend their rights. Because of this, Super Babies moved for default judgment, which was ultimately granted. The USPTO canceled the trademarks, a decision that came as a shock to many of us in the IP world. So why didn't Marvel or DC respond? We can only speculate. Maybe they felt like their position wasn't strong enough. Maybe it got away from them. Maybe they thought it wasn't worth the legal battle. Either way, the result is a major shift in the comic book trademark landscape. This case raises some fascinating legal questions. First, it reinforces that trademarks must be distinctive and not generic, which we know. If a mark loses its distinctiveness, meaning when consumers can no longer associate the term with a specific source, then is when it can be challenged and potentially canceled. In this case, Marvel and DC allowed the term superhero to be used so widely that it no longer functioned as a brand identifier, and that is the key takeaway here. Another aspect is that two competitors, Marvel and DC, jointly owned a single trademark. And this is where things can always get tricky. Super Baby's petition argued that this joint ownership resulted in abandonment of the trademarks because the marks couldn't serve as an exclusive identifier or indicator for its origin. By sharing the trademark, Marvel and DC blurred the lines of ownership, leading to the perception that the terms were nothing more than a genre. So, what does this decision mean for the future of comic books and IP law? Well, for one, it opens the door for other creators to use the term superhero without fear of legal backlash from Marvel or DC. It also serves as a reminder that we can't lock down generic terms, even if you're the biggest name in the industry. Hey, it's a win for the little guy, a huge lesson in trademark law. If you're a creator or entrepreneur, this case highlights the importance of carefully selecting your trademark and consistently enforcing your rights. Otherwise, you risk losing them. That's all for today's video. What do you think about the cancellation of the superhero and superhero trademarks? Do you agree with the decision, or do you think Marvel and DC should have fought harder to keep them? Let's chat in the comments below, and if you're interested in more deep dives on legal battles, small business stories, and trademark disputes, don't forget to hit the subscribe button and click the notification bell so you'll never miss an update. Thanks for watching, and I'll see you in the next one.